My lord, the business of the day is for the hearing of the matter, and the claimant is ready, so connected. Subject to the court's convenience, we are ready to move on. Very grateful, my lord.
Hello, witness. Can you hear me?
Yes.
Yes, my lord. We have only one witness.
Are you a Muslim or a Christian?
I am a Christian, sir.
Please, you need to speak out audibly so that
I am
the
a
court.
Christian, sir.
Please, you repeat after me. I swear in the name of Almighty God
I swear in the name of Almighty God
that the evidence I shall give in this case
that the evidence I shall give in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
May Lord the witness on God.
Witness, please tell the honorable court your name, your address, and what you do for a living.
My name is Imabasi Esu. I reside at number 11 Alhaji Lateef Shofowura Street, Bagada, Lagos. And right now, I am unemployed.
Witness, do you recall deposing to a written statement on oath on the 9th day of March 2020, as well as on the 12th day of March 2025?
Yes.
The first one, my lord, is deposed to on the 9th of March 2020. And the second, the additional one, is deposed to on the 13th day of March 2025. It's actually 12th. I think they made a mistake. It's 12th of March 2025. Is that correct?
Yes.
No, my lord. The first one is 2020 and the second one is 2025. Yes, my lord. Is that correct?
Yes.
Do you also recall deposing to a certificate identifying statements contained in documents made pursuant to Section 84 of the Evidence Act 2011 on the 9th day of March 2020?
Yes.
If you see all these documents, can you identify them?
Yes.
My lord, the one is on the 9th of March 2020. That's a certificate under Section 84. 9th March 2020. Do you identify these documents as the documents you deposed to?
Yes.
2020, my lord. 9th March 2020. 2020. Having identified these documents, what do you want to do with them?
I would like to adopt them and want the court to admit them into evidence.
As your evidence in chief.
As my evidence in chief.
Miss Esu, in paragraphs, okay. In paragraph 6, 7, 8, 9, 10, 11, 13, 14, 15, 16, 20, and 21 of your written statement on oath. Yes, my lord. 13, 14, 15, 16, 20, and 21 of your written statement on oath of 9th March 2020. You made references to some documents. These documents, if you see them, can you identify them for the court?
Yes.
Good. One of the documents, the one you made reference to under paragraph 20, which is your letter of demand for entitlement. Where is the original of that document?
The original is with the defendants.
Okay. Thank you. And then the letter of employment, which you have already said that you can't find, but you were able to get the soft copy out of your computer under section 84. The original, you've made every attempt to locate it, you could not find it, but you have the soft copy which was printed and certified. Is that correct?
Yes.
Very well. That's letter of employment, my lord. Is the post 2 is under paragraph 1. But the copy has been of the statement on note of 9th March 2020, my lord. She also has a copy, but she could not find them, but she has a soft copy on her laptop, which she printed, and we brought it under the section 84, certificate electronically generated, my lord. My lord, I seek to tender the pleaded documents. Yes. My lord, those are the documents which have been pleaded by the claimant. And yes, my lord. The others are under the certificate. My Lord, the certificate identifying statement contained in document was filed alongside with the originating processes. That's why it's dated 9th of March 2020. And everything was served by the registry of this honorable court. They were served together, my Lord. I'm grateful, my Lord. Oh, please.
Zoom.
Yes, my Lord. As the court pleases. Very grateful, my Lord. I will undertake to do that, my Lord. Once I know the particular letter my learned friend is talking about. As God pleases. As God pleases. Very grateful, my Lord. Miss Esu, please, what do you want this honorable court to do for you? Audio. I think. Can you hear me? Can you hear me, please? I think you are muted. You are muted on your side.
I'm unmuted.
Yes, please. What do you want the honorable court to do for you, please?
Please, I want this court to grant my claims and relief sought under my complaint before this honorable court.
My Lord, that will be all for the witness. Very grateful, my Lord.
Madam, can you hear me?
Yes.
Okay. Please, you are aware that your lawyer wrote a letter to the defendant. The defendant is SO and you. To the defendant, a letter dated 17th February 2020. You are aware of that letter?
Yes.
17th February 2020. The facts that are stated in that letter, they were what you informed your lawyer, is it not?
Could you please ask the question again?
The facts that were stated by your lawyer in the letter to SO and you informed your lawyer of those facts. Is that not true?
Yes.
Do you remember when this case was filed in court? Do you remember the dates? Do you remember the dates this matter was filed in court?
No, I don't.
Okay. But it was definitely after your lawyer wrote to the defendant, is it not? Certainly it must have been.
Could you please could you ask the question again, please? I'm not understanding your question.
This matter was filed in court after your lawyer wrote to the defendant. Is that not true?
Yes, it's true.
So I would be correct to say that your narration of events to your lawyer, but at the time you made that narration, the events were better to your recollection than when the matter was filed. Is that not true? It was fresh in your memory when you spoke with your lawyer compared to when you went to court. Your recollection was better. Is that not true?
I don't understand.
When you spoke with your lawyer and you told your lawyer what happened, your recollection of events was better than when you went to court. Is that not true?
I'm just coming to court now, so.
When you filed the matter in court, that's what I mean. When you spoke with your lawyer and your lawyer wrote a letter, you had a better recollection of the events than when you filed the matter in court. Is that not true?
I'm not sure. I can't.
My lord.
I don't understand the question.
When you went to your lawyer, you told your lawyer what happened, and your lawyer wrote a letter to defendants. As at that date, you were telling your lawyer what happened, your recollection was better than when you now filed the matter in court because it was closer to when the event happened. That's all I'm saying. So you had a better recollection of events when you spoke with your lawyer than when you came to court.
My lord, I think I have to. Yes, exactly.
No, not
exactly, my lord. That's my
matter
point.
of facts.
No. You're asking for the mind of the witness,
which is
as accomplices.
Which is only what she only would know. She's the only one that can know that. Whether she had a better recollection when she spoke with her lawyer than when she came to court. That's all I'm asking her. So please, madam, I hope you understand the question now.
Not really. I don't know. Can you ask it a different way? I'm not really understanding.
When you went to your lawyer and you told your lawyer what happened, that made your lawyer write this letter of 17 February 2020, you had a clearer recollection of what happened than when you came to court. Is that not true? I believe the question is clear now.
Yeah, but my recollection has not changed.
So in the event that there is a difference between what you told your lawyer and what you have told the court, what you told your lawyer is more accurate. Is that not so?
My statements, I stand by the statements that I have made and I was deposed to. That's what I stand by.
So you are abandoning the ones you informed your lawyer that made your lawyer write the letter? Are you abandoning it? As accomplices. Okay. You had resigned on the 17th November 2018. Is that correct? Is it correct that you resigned on 17th November 2018?
I did not resign. I informed the head of HR of my intention to.
Did you actually that she resigned on the 17th of November 2018? That's a question. She said the HR of her intention to resign, that she did not resign. You actually wrote a resignation letter, is that not so? And you submitted it to the defendants.
I did. I wrote to the defendant of my intention to resign, yes.
And you submitted it to the defendant. And that letter was subsequently, you withdrew it subsequently, is that not so?
Yes.
Now, you said you were employed by the defendants in February 2015. Is that correct?
Yes.
2015. But in actual fact, this offer of employment of February 2015, you rejected it. Is that not so? You rejected it, yes. Exhibit 1A, EE2, yes, my lord. What is the offer? Of employment, which the claimant says is the basis of our employment. You rejected it, is that not so?
I have never rejected any offer of employment from the defendant.
So what about the letter of employment of October 2015? Was that not issued to you?
I'm sorry, I don't understand your question.
Your letter of employment, which you have here, is February 2015. And I asked you whether you rejected that offer of employment. You said no. And I'm now asking you, what about the offer of employment that was made to you October 2015? What brought that about? Was it not a rejection of this offer that made the defendant make you a fresh offer in October 2015?
I'm not sure. Well, I'm not sure of I'm not sure of it, because my employment with the defendant has been first on contract, and then I was confirmed as a full employee. So
but this is not a confirmation letter I'm talking about. I'm talking about a fresh offer of employment. You say you are not sure, you don't recall it?
fresh offer of employment.
Yes.
I would like to look at the.
Do you recall seeing the defense process in this matter that you made a reply to? Do you recall seeing the documents for the defense?
Yes.
Do you recall seeing a letter of October 2015 there?
I recall seeing the response to my statement, and also the documentation that was placed in, though I was not in agreement with everything that was
But
present.
surely if you saw that letter and it was never issued to you, you would have flagged it. Is that not so? If
My
you saw
lord,
a letter that was addressed to
my
you
lord,
and you never
the
received it,
documents being referred to by my learned friend are not before this honorable court, are not formally before this honorable court.
My lord, the claimant is not going to come back to give evidence. So this is the only chance we have to ask her about the facts. So even if the documents have not been tendered yet, the defense was served on her and she read it and she saw the documents. So if we don't ask her questions now, we can't ask her later. I'm grateful, my lord. Yes. So you say that you did not see it, the October 2015 letter, so as not to waste time.
I did not say that I did not see it. I said that I saw the response and the documents that were there.
How many offers of employment did you receive in 2015?
I do not recollect.
Okay. So I'll put it to you that you received another offer in October 2015 because you rejected the one of February 2015. And what is your response to that?
I do not recall.
Okay, so I'll go on to your reliefs now. You said you want 3 months salary in lieu of notice. That is your reliefs, the reliefs the claimant has claimed. First, you said that you want a declaration that the letter of dismissal for abandonment of duty is unfounded, invalid, malicious, baseless. Do you recall that?
Yes.
Now, do you recall that you returned to the country from your treatment in December 2018? 2019, sorry. December 2019.
Yes.
And you were at work from 10 to 16 December 2019. Is that not so?
Yes.
And from 2019 to when you received that letter, you were not at work. Is that not so?
Yes.
So December 2019. So you are also asking the court to give you 3 months salary in lieu of notice, which is on the basis of the defendant's letter dated March 18, 2019. Is that not so?
Can you come again?
You are asking the court to give you 3 months salary in lieu of notice, in place of notice. That is as stated in the letter from the defendant dated March 18, 2019. Is that not so?
March 18, 2019.
Yeah.
I don't recollect a letter of March 18.
You don't recall the date, at least you recall that you asked for 3 months salary in lieu of notice. Do you recall that?
Yes, but not March 18, 2019.
Okay. What is the date?
I don't know. In 2019, I was undergoing treatment, and I was in 2019, March 2019, I was still undergoing treatment. I did not have a letter requesting dated that date.
You have a letter here, part of the documents that you have relied on is dated March 18, 2019.
That I sought relief. Sorry,
no.
Can you explain?
Letter of increments I'm talking about.
Sorry.
Letter of increments. March 18, 2019.
Letter of increments. Okay, because you said seeking relief in 3 months in lieu of notice based on that. Okay. Yeah, I was asking for 3 months salary in lieu of notice, which is the standard thing if you are terminating an employee's appointment. Yes.
So, having been dismissed as a former employee of the defendant, you are aware that an employee that is dismissed is not entitled to salary in lieu of notice. Is that not so?
I was not dismissed. That's why we're here.
Started from the letter of dismissal, which you said you received.
I received the letter of dismissal after I had sent in the demand notice, because I don't know if I should clarify the way things are, because the way you're asking the question is a little bit confusing. And it's what happened is that I got back to the country in December of 2019. I resumed work as I had agreed with the head of HR, one of the defendants. As agreed with her, I resumed work. And when you say that I have been at work, I stopped, from 16th, I didn't go to work. The agency normally closes for the year. And they had an end of year party of which the agency closes and resumes in January of the following year. So this was around the period that there was that the agency was closing. So I got to work and I was called in and verbally told by the two defendants what I have claimed in my statement. And this is why I do not agree that I was dismissed when I sent you that, when I requested for information. Why? One of the reasons why we're here is because there was a lack of information of this letter. of backing up the verbal conversation that we had. And I was waiting for feedback from one of the defendants, any of them, as they promised on that day that I met with them, and they told me that my services were no longer required. When they told me that, I said, okay, am I getting a letter? What is the reason for you no longer requiring my services? And they gave me the reasons that I stated there in my statement. And I said, okay, I cannot force you to employ me. It's your right. However, am I going to get a letter? Will I be compensated? And they said yes, that this was going to happen. And I had no reason to doubt that this will happen, because it's not the first time that we have had different conversations and it has been backed up with written corroboration of same. So me contacting the first defendant to ask her, hey, I've not heard from you, what's going on? We had several conversations on electronic means as well as on the telephone, where she had, all the statements that she made were in line with what we had discussed in December. Only for after receiving the demand letter, after receiving the demand letter, they now sent this dismissal and changed the tone, which is why we are here today. Because they had made it clear to me that I did not need to come back. In fact, at that point, one of the defendants told me I don't need to come back anymore. They were even arguing between themselves. Like, one was saying, oh no, you come back. And the other one said, no. My direct boss, she told me, no, Ima, if we need you, we will call you, but you don't need to come back. There was no need for me to come into the office again from that 16th to January. There was no need. In January, one of the defendants contacted me, asking me to discuss my final entitlements for an employee that you claim that is dismissed and has abandoned duty. Why are you negotiating with me about my final entitlements and if I want to keep the office laptop or not? Because these are the conversations that happen, all of this before I sent the demand letter. I sent the demand letter because I sensed that things were not she was delaying in sending it. So I wanted to escalate it to the first defendant, the group managing director. I felt that maybe he did not know what was going on. And I escalated that by sending that letter.
You said all this in your witness statements, madam.
Yes.
We will go back to that meeting of 16 December, but I want to finish with your claims first. So you also said that you want the balance of the December 2019 salary in the sum of 342,457 naira 97 kobo. Is that correct?
Yes.
Now, you recall that you worked from 10 to 16 December. Is that not true? And after that, you no longer went back to work.
Yes.
So going on to the share of profits, 2018/2019, you are asking for 660,000 naira, 912 naira, 69 kobo. Is that not so? For the share of profits for 2018/2019. Is that not so?
As stated in my letter, yes.
Yes. So you said in your witness statements that the defendant told you that they had a loss in 2019. Do you recall saying that?
Yes.
And you are at the same time asking for a share of the profits when you had been informed that they had a loss. So your statements contradict each other, isn't it?
No, not entirely, because the profit sharing that I requested for is based on memos that were issued to me from the company saying that issued for me from the company saying that it has been put in my allowances account. And
this memo, you do not have any of them before the court. Is that not so?
Sorry?
This memo that you say were issued to you, you don't have any of them before the courts. Is that not so?
I'm
You
not
or
sure.
do you not? We need to move on.
My lord, that statement, my client might not be able to remember because of the time, but the document speaks for itself. If it's in the court's file, it will be there. If it's not there, it's not there. But
So-
asking her to now where she is and how she is now to be confirming something that is in the court file, I think that is asking too
The
much from my
final
client.
question on the profits is that this figure that you have asked for is just a speculative figure. You don't actually have any knowledge that's from the basis of this figure. Is that not so?
All the relief I am requesting is founded.
Okay, I'll go on to the bonus. The same thing with the bonus. You just put a figure. You actually have no information of whether there was even a bonus. Is that not so?
All the relief that I am requesting is founded on the documents that were on the statements that I've made.
So we'll now go on to the claim of 3 million naira, which you said was communicated to you by the letter of increment dated 18th March 2019. Now, that document says that the sum of 3 million naira is tenured contribution to vehicle acquisition. So the company was going to make a contribution for you to get a car. Is that not so?
Yes. Yes,
And
that was the agreement, yeah.
And this 2019 was the year that you were away on sick leave. Is that not so? That you returned in December. Is that not so?
(2019) is the year I was away on treatment, but not all the time. It was from June. I was still working even while I was receiving chemotherapy. I was still coming to work and doing what I needed to do until June, when I traveled for surgery and radiotherapy.
You recall that you sent the defendant an email on April 24, 2019, giving the defendant a schedule of your treatment. Do you recall that?
I recall.
And that schedule started from May 6th. Is that not so?
Yes, the first surgery was on May 6th. Yes.
So you were away from May 2019 to December 2019. Is that not so?
Yes.
And before you left in May, you weren't going to work regularly because of your treatment. Is that not so?
I was going to work regular. I don't know what you mean by regularly. Because my schedule.
Yes.
My schedule.
Treatment, you were not going to work on your treatment dates. Okay, maybe I can be specific. I'll refer you to your email of 31 January 2019.
Okay.
You were notifying the defendant that you would not be available February 1, February 2 to February 6, February 20, February 22, February 23 to 27, March 13, March 15, and March 16. Do you recall that?
Yes.
And apart from these dates, anytime you had an urgent need for treatment, you would also ask for permission. Is that not so?
These are the dates that I had maybe doctor's appointments or follow-up or something like that. But outside of that, I was coming to work regularly.
So you would agree that in 2019, you did very little work due to your health condition. Is that not so?
I don't agree that I did very little work, because in as much as I was not physically in the office, I was still, I'm a team leader and a business group ahead. So I was still remotely working. So I don't know, when you say very little work, I
Due to your condition of health, you were
No.
unable to do
No.
work. Is that not so?
I was not unable to do work. When I wrote those mails, it's mainly because I was unable to come in physically to the office. It doesn't mean I was not working.
So this period, I am putting it to you that all this period, apart from the period you even notified the defendant, you were not really working because of your health condition.
Not correct. Not really working.
On to the last relief. You are asking for general damages of 50 million naira for pain and suffering for the defendant's treatment of you. Now, when you inform the defendant of your diagnosis, the defendant was very supportive. Is that not so?
Yes.
And the defendant made a payment to you of 1.5 million naira. Is that not so?
Yes. But I don't know. Okay, let me let it do. Yes.
And your HMO insurance is 1 million naira. Is that not so? Which also contributed to the treatment. Is that not so?
Yes.
And your colleagues made a contribution for you. Is that not so?
Yes.
Now, despite all these actions showing support, you still come to court to blame the defendants for pains and suffering and stress. Is that not unfair?
No.
So I'll go on to your first employment, which I had spoken about earlier. Now, I said you had rejected an offer of employment and then you were given a fresh one. So it shows that you had a general disposition of not being satisfied with your conditions of work. Is that not so?
Not true. It doesn't show that.
The reason you resigned in 2018 was because you were not satisfied with your pay. Is that not so? Your resignation of November 2018.
Yes.
And the reason you also rejected the offer of February 2015 was because you were not satisfied with the pay. Is that not so?
Not true. I don't know, the reason for the resignation or the intent or my written intent to resign is because it's a culture of the company. They will not, I had different team members and I'm the head of the team of the business side. And incrementally, they were behind, I don't know, at some point they were negotiating with my other colleagues and increasing their pay while I was still on the same pay. And the defendant had promised, oh, we're going to look into it. And it was not done. And this had been since I had joined, and my workload had increased tremendously, and we're doing very well because I had one goal and I was achieving all my goals. So at the end of the day, I'm sorry, please let me finish. At the end of the day, she said that she was going to do it and she didn't. And it is the culture of the company. You threaten to resign and then that's when they will come to the negotiating table to do what they say that they were going to do. So
we're on the same page now. You would threaten to resign and then they would make you an offer. Is that not so?
It's only once I have done that. And that was on 2018. I did not do it in 2015. No. It was in 2018 that happened.
No. You said you were not allowed to go on leave and then your conditions of work were not conducive. Did you not say so?
Yes, I was not given leave when I needed to when I wanted to go on leave. this is outside of my illness when I was ill. But even outside of that, you would, yes.
You recall that in 2017, you went on leave. 2017, April, 5 to 11 April 2017. Do you recall that? That you requested for leave and you were granted?
Yes.
Do you also recall that you requested for leave October to November 2016, you were granted?
Yes. I'm not saying, what I'm saying is that you will not be allowed to go on leave. There's no days off. Every other, the business that we worked on required us almost 24/7.
April 2017.
So
11 April 2017.
yes, I'm not saying that I never went on leave.
October 31.
It was frowned upon.
November 22, 2016.
I'm not claiming that I have never gone on leave. I am saying that
yes,
you were not allowed to go on leave when you needed to go on leave.
November 31 to November 22. Yes, my lord. Yes, my lord. So you said that your condition of work was so stressful because you were not allowed to go on leave. But you were aware that you were handling and engaging and a demanding account. Were you not handling a demanding account when you were with the defendant? Is that not so?
Yes.
And were you paid an inconvenience allowance?
Yes.
Okay. So from the inception, my lord, from the beginning of her employment, she was paid an inconvenience allowance. Now, what you said about having to resign before defendant would consider your terms of employment, it only applies to you, is it not so?
No, it does not.
You are the only one who was threatening the defendant with resignation. Is that not?
That's not true.
You are aware that while you were on sick leave, the third Mrs. Biodun Adefila was promoted. Is that not so?
Yeah, she informed me, yes.
And she didn't threaten to resign. Is that not so?
I don't know. I cannot speak for her. I cannot speak for how she got promoted. I cannot say that. I can only say that she informed me that she got promoted. And I cannot speak for her in particular, but I can speak for my team members because there's quite a number of examples that have had to, and as the team leader, I had to manage those conversations.
You recall that you said that your team members were being promoted. You said that in the course of your testimony. Is that not so?
It's just I didn't say they were being promoted. I said they were giving them, increasing their salaries. I didn't say increments. Yes, salary increments. That's different.
And salary increment was the basis of your resignation. Is that not so?
Sorry?
The basis of your resignation was this salary increment. Is it not so?
I'm not understanding the question.
You resigned in 2018 was because you wanted your salary to be increased. Is that not?
Yes, because they had promised to do so and it had not happened.
Now, would I be correct to say that your relationship with the defendant was not good from the beginning because you were always complaining about your terms of employment?
No, it's incorrect. It's incorrect because if my relationship up to all the time I was working, I've not had any, like I said, I have now, this is the first time in 2018 that I actually requested increment and it was an issue. I I have not had a bad relationship with any of the
So your
defendants.
salary was increased before 2018, was it?
A general salary increase in the company was done. And also when I transitioned from contract to full employment, that happened. Like I said, in between then and that 2018, there was a whole lot that was happening, and my other team members, especially my co-team member, because the way the business works is, or the team works, is that you have the business side and you have the creative side. So the creative director, his salary was increased like almost every 6, and we knew about it. We didn't know when it happened, but we knew eventually because he threatened several times to leave. We had even at some point one of the defendants, the group managing director, had called me to his office that I should help him to manage the situation because it was like a bull in the China store. And so it is something that has always happened, and I have never actually
so you were
done that before.
You were following an example. Is that what you're saying?
Sorry?
You were following the creative director's example.
I was not following his example. I was not following his example. I was trying to get them to honor what they had promised to do. Because
my question, madam, is that as an employee who was always dissatisfied, your relationship with your employer could not have been good. Is that not so?
I'm sorry, I disagree with your categorization and description of me as an employee that was never satisfied. You cannot speak to how whether I was satisfied or not. I only told you once that I requested because they had promised. See, when you are working, you have.
I think you've said enough.
At appraisals,
maybe you want to agree more in your examination so that we don't waste time. You recall that you said that the former second defendant, who is the managing director or the defendant, spoke about you in unpleasant terms. Do you recall saying that?
Sorry, you said the second defendant. I don't know.
The managing director of the company.
The managing director of the company.
Yes, he was the second defendant, but has now been struck out, Mr. Odemelfort. You said he spoke about you in unpleasant terms.
Yes.
You recall that? So in essence, for your employer to speak about you in unpleasant terms, you didn't have a good relationship. Is that not so?
That is not true, because he has also spoken about me in pleasant terms. Like I said, what he said, what I was referring to was a particular incident. I have known this first defendant since 2000, when I started my career in that same company. If I did not have a good relationship with them, I worked with them for almost 6 years before I left to go and work on the client side of the business. It was not on acrimonious terms that I left. If it was on acrimonious terms, they would not have sought me out to ask me to come back, because I am a top performer in my field. So if it was on acrimonious terms and I did not have a good relationship with them, they would not have come back to come and take me from Nigerian breweries and bring me back, because they knew I was the right person for the job that they needed to do, working on that business, because it was a very demanding business. And they know I am very dedicated and I'm result oriented. So I reject that statement that you made, saying that madam, I had a bad relationship.
To you, madam, that even if your performance was good, your relationship with them was not good.
My relationship was very good, so good to the extent that I knew his family, I knew their families, and I had interactions with all of them, not just official interactions. And you don't have that kind of a relationship with a disgruntled or a bad employee. I traveled for his 60th birthday and paid my way down to Akwa Ibom to celebrate with them.
What you have said before the court contradicts what you are saying, madam. From what you have said before the court, you are claiming that you were badly treated.
I was badly treated on this particular instance. So
So
if
you
I'm,
always
I'm badly treated on one instance, it does not erase all the years of good relationship that we had, to the extent that my parents, sorry, ma, please, I want to make it clear, because I don't like the fact that you're making it seem as if it is a one time and that's it. This
Okay.
man, he
It's
knows
okay. You don't
my
have to
parents.
go on and
So
on.
if
Take
I
time.
don't think he knows every
Your
employee's
answers have to
parent.
be set to the questions, please. So let me go back to the meeting of 16 December 2019.
Okay.
As the court pleases, that's actually the last set of questions. The meeting of 16 December 2019. Your recollection of that meeting is confusing, is that not so? You don't actually remember what happened.
No, it's not confusing. That is the statement that the defense put in their response, and I refuted it vehemently. I was not hallucinating, or I was not confused in any way.
Do you realize that what you told your lawyer that happened is different from what you have told the court in your witness statement? Do you realize that?
No.
Okay. So I'll go on to your pension and your tax. You said you wanted the defendant to confirm 2019. You said you wanted the defendant to confirm that they paid your pension and your tax. Is that so?
Mm-hmm.
Now, your pension account is yours. You had it before you joined the defendant. Is that not so?
Yes.
And you have access to it even up to today.
I now have access to it, yes.
Your access was blocked at the time. Was your access blocked? Okay. Your tax, the same thing. You have access to your tax statements. Is that not so? Madam, you have access to your tax statements.
Oh, sorry, yes.
Thank you. That will be all, my lord.
My lord, there's no redemption. Yes, my lord. That will be all for the claimant. Very grateful, my lord.
Yes, my lord, physically.
As the court pleases.
July 14th. 14th of July.
July 14th.
It's convenient, my lord.
It's convenient. Yes, my lord, a lone witness. Thank you, my lord.
Thank you very much. Okay, I didn't know you were for
Thank
this matter.
you.
I thought you were for the second.
I actually thought so because it was
the
the lady
other-
I'd been speaking with.
Yeah, that's Yinka.
Okay.
It's another shape, but she has another one.
Oh,
We met once at the Court of Appeal at CBS.
Eh.
We were doing the congestion, and there was an issue about your matter that has been probably disposed of in lower court, and you have a criminal objection, and they are saying no. That has been taken. I remember the case. So when you ask me, okay, who is the madam that we have won at the Court of Appeal?
Okay, are you in that matter? You're not.
No, I'm not. I think I'm not.
Eh.
Chairman, thank you
Mother,
for giving us this the reception, or the one reception.
Thank you.
Is it Monday? 14 is a Monday.
Yeah.
Oh, wow. I didn't realize that.
Yes, I'm even.
Okay, you're closing for the year 15.
Two people. Ah. I'm supposed to go to work from one of my I won't waste time there. Then from what point you go in. Which side are you going to My 12.
Okay, not my 12.
My 2 na
My
towards
own first
let's
start.
start. Ah,
Yeah.
no, now the other side that they go.
Okay, no problem.
Thank
Have
you,
a
sir.
nice day.
God bless you, sir.
All right. So if you call her my regards to her, I think she's my sister.
Yeah, so
Uh-huh.
it's true.
Tell her I agree.
I will. I will.
All right.
Thank you, sir.
All right.